Hello there, I'm Faith Omar. We're in a world today where we have lots of creatives everywhere doing amazing things, coming out with amazing solutions and tools all over the places. And we see young ones doing a lot of things around tech, and it's quite an amazing experience. But you know the game changes as a creative with your intellectual property once you are under an employment. As an employer or any organization that wishes to employ a creative, it is expedient that at the point of hire, certain things are clearly stated out. Because once you are under an employment as a creative, it means all of your intellectual property or output in the course of that employment belongs to your employer or the organization that has hired you. So an employer at the point of your hire expressly states a lot of things that has to do with the intellectual property, who owns it, the business IP, the licenses, rights, and all of those things are actually captured or are supposed to be captured in your employment later. And so you as the creative should do yourself a favor of going through these terms carefully. If you wish, get a lawyer, that's a third eye or a second eye if you might say, to go through these documents with you and explain what exactly the business intellectual property means. Because once you come under that employment, every of those outputs you bring from your skills or from your skill set belongs to the business. So you don't go ahead claiming what does not exist, and so that there's not a proprietary rights tussle at the end of the day. The employer has the right to document all of this processes, or to document copyright or even patent most of all of these outputs that come from the course of your employment as a creative. They will be within the prerogative rights to do that. So as a creative, if in the instance or before your employment you had this tool or solution that was already in existence, and when you were being employed you found out that these tools or solutions will be useful in the course of your employment and you deploy them to your employment or to your work process, in that case we can draw the line. The property or intellectual property remains with you, except in circumstances where your employer wishes to buy it over, or some compensation talks should happen between both you and your employer. But in such cases where those tools have been or those outputs have been before your employment, the intellectual property right actually remains with you. So it's important that you find out who the intellectual property belongs to at the point of your hire to prevent all forms of proprietary right tussles, either by the employer or by the employee. I believe you've been able to learn one or two things today as a creative and also as an employer in regards to intellectual property ownership.